Thank you, Mr. Chairman. Thanks to all of you for being here today and for all of your past and present service. I have some real concerns about the treaty, and almost all of them revolve around the fact that it does have a binding, or has several binding dispute resolution mechanisms, which if we enter into the treaty, we would be bound by. And I just think in the current international environment, those are very likely to be stacked against us. And also in the current international environment, there's very much a trend toward internationalizing what I would consider domestic issues and litigating them in an international forum. And I'm very concerned about all of those related trends. In that context, Professor, I wanted to ask you, Professor Oxman, you mentioned a few minutes ago in terms of the arbitration panel, the parties choose the arbitrators. As I read it, they try to choose the arbitrators, and if they can't, somebody else, the king of the law of the sea land, chooses 3 of the 5 arbitrators. Isn't that the case?
Absolutely, Senator. First, I want to say that the concerns that you've expressed about compulsory dispute settlement procedures are concerns we always have to look very, very carefully at. And the glass in the Law of the Sea Convention is neither half, it's not all full and it's not all empty. We would try to be very careful on that. As to the arbitration, what you describe is correct. When lawyers draft arbitration clauses, not just in treaties, the whole question is what happens if the parties don't appoint their arbitrators, and the answer is to try to find a neutral appointing authority. In the case, under the resolution of advice and consent in the 2004 report, we would opt for arbitration under Annex 8 with respect to the subjects covered there. And there, the appointing authority, if agreement couldn't be reached, would be the Secretary General of the United Nations, currently from South Korea.
Professor, I don't want to cut you off, but I want to preserve my time. The bottom line is, if the opposing party to us in a dispute wants to make it so, they can ensure that a majority of arbitrators is chosen by either the head of the UN or the head of this new Law of the Sea entity, correct?
If agreement cannot be reached, that's right, but they're running a risk.
It is correct, and it is a problem.
I think that is a recipe for disaster for us. In line with that, is there any clear provision of the treaty that exempts intelligence matters from binding dispute resolution?
Yes, Senator. My understanding is that the Departments of Defense, the Central Intelligence Agency, and related agencies have taken the position that their intelligence activities at sea are military activities. I'm obviously not an expert on this, but there would be no reason for me or anyone else to question that determination, and of course there would be a declaration excluding military activities from compulsory settlement.
So in other words, excluding our intelligence activities from binding dispute resolution depends on their being considered military.
And being activities at sea, otherwise they're not covered at all.
Right. Now, I would just point out here on Capitol Hill, we have a committee that deals with military stuff. We have a completely separate committee that deals with intelligence stuff. But let's go on to the military issue. Is there anything in the treaty that clearly says who will decide what is a military activity and what is not a military activity?
The treaty gives any state the right to exclude military activities. I don't think it went any further, because I think if one tries to follow through how you would make that determination, it is extremely difficult to imagine a situation in which you could second-guess a determination by any state that its activity is military, because it's the one that understands the purpose for which it undertook the activity.
Well, I have no doubt that there are plenty of countries around the world who will second-guess that determination of ours. And so my concern is that there is nothing in the treaty that says who decides that threshold jurisdiction issue. When you're in a court in the U.S., not that it's, I realize there are differences between domestic law and international law, but when you're in a court in the U.S. and you go before a court and one side says this court has jurisdiction and the other side says this court doesn't have jurisdiction, you know who decides whether the court has jurisdiction? The court, not the party that says you don't have jurisdiction. So I think that's a very serious issue.
And that will be the case here, too.
Final issue on environmental issues. Professor, you, in terms of land-based pollution points, sources, you point to Section 207. As you know, or Article 207, there is a separate Article 213, which is entitled Enforcement with respect to pollution from land-based sources. If everything about land-based pollution is purely feel-good, hortatory, why would there be an article entitled Enforcement with respect to pollution from land-based sources?
Senator, Article 207 does require a state to adopt laws to control land-based sources. We have extensive state and federal laws on that subject. There's no doubt that we have done so. Article 213 requires us to enforce those laws, which we do. That's all it does. It is not possible, as I see it, for us to violate that provision.
If it's not possible for an individual state to violate the provision, why is it in the treaty?
Because many of the pollution provisions of the treaty are what we call framework provisions. It's what I mean when I call the convention a constitution for the oceans. It sort of lays out what the objective should be in other negotiations, but it doesn't tell you the bottom line. And that's what's happening here. The purpose is to encourage states to deal with the question nationally and internationally, but it does not tell them precisely what they have to do.
But again, it seems odd to put a feel-good provision like that with the title Enforcement with respect to pollution from land-based sources, because this treaty does have enforcement mechanisms. I would just, finally, my time is out, but in conjunction with the same point, I'd point out that this isn't wild speculation. I just have one article here by William Burns, another law professor, about the upcoming litigation onslaught of environmental issues under this treaty. It's titled Potential Causes of Action for Climate Change Damages in International Fora, the Law of the Sea Convention. And he says, the United Nations Convention on the Law of the Sea is a promising instrument through which such action might be taken, given its broad definition of pollution to the marine environment and the dispute resolution mechanisms contained within its provisions. So I just use this one article to point out this isn't wild speculation. They're a team of international lawyer types chomping at the bit.
Could I just add one point to that, sir?
I'm sorry, we've gone 8
May I submit something for the record on the message?
Absolutely, absolutely.
I also have a letter from 30 groups that have opposed this treaty, which if I may have your permission to insert it in the record as well, I'd appreciate it.
Without objection.
Thank you, sir.